In this case, we'll discuss cases. What is a case? Well, let's start with what a case isn't. People come in here all the time and want to know whether we have cases. We do, we assure them, but then we ask what kind of case they're looking for. Invariably, it turns out they want to see the records in their case, meaning either in an ongoing superior court case or one that they were involved with in the past. That's not what we have. We have no more access to the trial court's records than you do from your home computer. Westlaw does give us access to some past California trial court opinions, but not to the current court's records. Then what kind of cases will you find here? Well, mostly we have appellate decisions. By decisions, I'm talking about the court opinions in the intermediate appellate courts and the courts of last resort. For example, we have books that include the decisions of the U.S. Supreme Court and the California Supreme Court and the U.S. Court of Appeals and the California Courts of Appeals. At least most law libraries do. Indio is somewhat limited. In some libraries, they also have books that publish select federal trial court decisions, and in a few states, there's even books containing state trial court decisions, but not in California. Now, what do I mean by decisions? I mean the opinions the judges or justices write when they decide a case. Let me mention that the intermediate appellate court judges are called judges, and the court of last resort justices are called justices. So what is an opinion? An opinion tells you the judgment of the court and explains the reasoning the judges use to reach that judgment. A judgment is, for example, affirmed or reversed. Now you may be wondering, why do I care about the reasoning? Just tell me what the court's judgment was. Well, we care for a number of reasons. One is because it's those opinions that give lawyers the ability to give legal advice. By doing some research, they can find out how the courts have handled similar cases in the past and use the reasoning the courts used to apply to the facts in the case in front of them and then give legal advice based on it. Also, the trial court judges can use that reasoning as precedent for future cases, apply that reasoning to the cases in front of them to decide them. The reasoning also helps explain things to the public. If you want to know why the court decided a case the way it did, you can read its explanation of its reasoning. And maybe most importantly at all, it gives law professors something to use to torture law students. Are there different types of opinions? Well, of course there are. It wouldn't be the law if we didn't find a way to make it complicated. Now, there's three main types of opinions we're going to talk about: majority opinions, concurring opinions, and dissenting opinions. And there's also two special situations I want to go over to make sure you know what they are and can spot them when you see them. And they are per curiam opinions and plurality opinions. Now you're probably wondering, where will I find these opinions? Well, just be patient, we're getting there. First, you need to understand something that's a little strange. And that is that some cases are designated by the courts to be published and some aren't. And we refer to those as published versus unpublished opinions. Sometimes you'll hear them called reported versus unreported opinions. I tend to use them both. Now here we're primarily talking about the intermediate appellate court. All U.S. Supreme Court and all California Supreme Court cases are designated published. That's probably true of all the courts of last resort in all the states, but I don't actually know that, so I'm not going to say it. So when the intermediate appellate court decides a case, it will designate it to be published or not. Now, it was back in the 1960s that the Judicial Conference of the United States began to express concern over the number of cases coming out of the U.S. Court of Appeals. They were multiplying like tribbles. The conference passed a resolution directing the federal courts to, quote, authorize the publication of only those opinions which are of general precedential value, unquote. It wasn't until the 70s that the circuit courts actually started doing it. And by 2022, only 14% of the circuit court decisions were designated published. And according to the Bar Association of San Francisco in 2022, only 9% of the California Courts of Appeal decisions were published. I was gobsmacked when I heard those numbers. I knew it was a majority that were not published, but I didn't know it was so few. Now you're probably wondering why. Does that mean I can't find these cases? They aren't published anywhere? No, that's because published versus unpublished is a poor choice of words. This is just a designation by the court and doesn't mean that you won't find an unpublished opinion actually published somewhere. A better word for it would be that unpublished means no precedential value. That is, at least not binding value, not mandatory authority. Are you allowed to cite unpublished opinions? Well, the answer is yes and no. In federal court, you can cite them, but they aren't binding precedent. So it's up to the court itself to which you cite the case that it might consider it persuasive or it might entirely ignore it altogether. This is actually the result of a fairly recent battle in the early 2000s that occurred over whether or not there should be unpublished opinions. So now you're allowed to cite them, but they are not binding authority. However, in California, you can't cite them at all. They have no precedential value except in a couple of circumstances. I'll tell you what those circumstances are, but they are beyond the scope of this legal research class. It's the law of the case, collateral estoppel, and res judicata. So feel free to look those up, but that's beyond the scope of this course. So back to opinions. The three kinds that I mentioned, the first was majority opinion. And this is an opinion that was agreed to by more than half of the members of the court or panel. Now, I said or panel because when we're talking about the intermediate appellate court, there's a whole lot of circuit court judges. And for each case, a panel of 3 is somewhat randomly chosen. So obviously, a majority opinion is one in which 2 of those judges agree on both the judgment and the reasoning of the opinion. A concurring opinion is one written by a judge or justice who was in the majority on the judgment and who agrees with the judgment of the majority opinion but does not agree with its reasoning. They're usually published right after the majority opinion in the books. And a dissenting opinion is one written by a judge or justice who disagrees with the judgment of the majority opinion. And obviously, if he disagrees with the judgment, he's also going to disagree with the reasoning. Now, those other 2 opinions that I mentioned, the first one is a per curiam opinion. And this is a court opinion issued in the name of the court rather than specific judges. In other words, no judge put his name on it. Typically, this deals with issues which the court views as relatively non-controversial, but not always. And I'll show you an example of one on the next screen. Now, the other one, plurality opinions, can be confusing, and I debated whether to go into it in this class, but I decided it's important for you to know what they are and how they affect your research. Basically, if there is no majority agreeing on the same reasoning, the case is weakened and technically is non-precedential. If you're relying on one, you need to keep this in mind because it's not a majority opinion. So let me show you some examples. The first one is a per curiam opinion, the beginning of one, and you'll notice it just says per curiam, so they're very easy to identify. There's no judge's name provided. But this is an example of a per curiam opinion that wasn't about an inconsequential matter. This was the case in which the Supreme Court selected George W. Bush to be president in the year 2000, even though Albert Gore had won the popular vote. Now let's look at a plurality opinion. Notice that it says at the beginning, Justice Kennedy announced the judgment of the court and delivered an opinion, in which the Chief Justice, Justice Ginsburg, and Justice Sotomayor join. Now let's take that apart. Justice Kennedy announced the judgment of the court. That means they had a majority of the justices that agreed, in this case, to affirm the lower court. But notice there's only 5 justices. Now, when a justice joins an opinion, that means he agrees with the reasoning. So these 4 justices agreed that the case should be affirmed, and they agreed with the reasoning that Justice Kennedy put out. But it's only 4 of them, and it takes 5 to decide a case in the U.S. Supreme Court, and that's assuming that 9 heard the case. Sometimes when a justice might not hear a case because he's recused himself, or it might be a vacant seat, like when a justice retires or dies. But at this time, there were 9 justices, and only 4 agreed with this opinion. Only 4 were on this opinion. So 4 agreed with the judgment and with the opinion, with the reasoning. But that's not enough to decide the case. So now we'll look at the concurring opinion that was filed. Justice Breyer, with whom Justice Kagan joins, concurs in the judgment. So they agreed that the case should be affirmed, but they had different reasoning. Notice it says, "But I do not rest my conclusion upon a strict categorical analysis." So they had a different reason for affirming the lower court. That made a total of 6 justices who agreed to affirm, which was enough to decide the case. So if you are relying on this case, in a case that you are arguing before the court, the judge might say to you, do I have to follow that case? It's not a majority opinion, if you're applying the Kennedy reasoning. And the answer is no. Technically, no. Now, most lower court judges, especially in the trial court, are going to say, Supreme Court, I'd better follow it, even though it's not technically binding authority, but it does weaken the reasoning a little bit. Just want you to be able to recognize those when you need to. So now we're finally back to your question, where will I find the opinions? And this is what will launch us into the next few videos. But first, let's talk about the publication process. When a case is first decided, it's released in what is called a slip opinion. Don't pay any attention to what it says on the screen. It says slip law. I do that all the time. I say slip law when I mean slip opinion, and vice versa. I will correct this when I edit the video, but it'll be obvious that I corrected it. So it's a slip opinion. And that's just exactly what it sounds like. Several pages, however many pages it takes together, produced by the court. That's a slip opinion. The courts then send those slip opinions to West Publishing, and West gets them ready to publish in books. Now, to speed the process of getting those books out to the law libraries, they first put them in some cheaply made paper-bound volumes that are called advance sheets. And then eventually there are enough cases in a couple of volumes of advance sheets to form a new hardbound volume, and then they take the advance sheets, they take all the cases that were in the advance sheets, and they put them in a hardbound volume, and they send out a new hardbound volume. Now, these books are called reporters. And what we're going to talk about in the next few videos is what reporters are out there, how to use them, how they're organized, and so forth. So, on to reporters.